Okay. So this is a public hearing in the matter of Yorgie's Barbecue, located at 1415 South Main Street, Bluffton, Indiana, before the Wells County Health Department hearing panel. Some general announcements before we get started, and I turn it over to councils to present their cases. Although this is a public meeting, it is an evidentiary hearing on a specific matter before the hearing panel, and general public comment will not be taken. Only individuals requested by the parties or this panel will be permitted to offer comments on this matter. Proper decorum will be maintained, and anyone not honoring the process will be removed from the facility. The parties and their counsel. The parties present for this hearing are the petitioner, Yorgie State Road Barbecue, LLC, by Matt Yergler, and his counsel, Mark Rutherford, sitting over here. Respondent is the Wells County Health Department by its representative, Brandy Shorey, and its counsel, Roy Johnson, over here on this table. The panel members, from my nearest to me to the farthest, is Bill Horan, Dr. Stephen Bales, and Marcia Meyer. I'm the hearing panel's attorney, Tony Crowell. Court reporters present, Deb Shantz, and looks like we have a few members of the public here as well. And also, we'll note that this hearing is being broadcast live streamed through Wells County Voice so that those who are not able to attend in person can sit at home and watch the hearing process. The procedure. The hearing panel met a couple weeks ago and adopted a procedure for this process to take place. So I just want to explain to the public what that is. So this board is not a court. There are no formal rules of evidence to be followed in the presentation by the parties of their cases, both in support of and in defense of the petition that has been filed. The goal of this proceeding is to allow both sides an opportunity to present their evidence and witnesses orderly, respectfully, and completely. The decision of the panel must be made only on the evidence presented at the hearing. The following is the procedure that the board will follow, subject to modification by the board at any time during this process. Opening statements. Each side will be allowed an opportunity to provide an opening statement. We will begin with Mr. Rutherford, and then he'll be followed by Mr. Johnson. Presentations of cases. Each party is requested to provide, they have provided a hard copy of their evidence to the hearing panel for review by the panel. Any stipulations? Did you guys enter into any stipulations?
I don't think a lot of evidence. We don't have any dispute about the mask wearing in the restaurant. There is a dispute, minor, about the 6 feet distancing and the capacity, but I think that will be it. I think everything else is
okay. All right. Thank you. Mr. Rutherford will be permitted to present his evidence first with the presentation of his witnesses and his evidence. Mr. Johnson will then be permitted to present his evidence following Mr. Rutherford's presentation with the presentation of his witnesses and evidence. If any rebuttal is necessary, the petitioner by Mr. Rutherford may offer any rebuttal evidence or witnesses in response to the respondent's evidence. Witnesses. Each witness will be questioned first by the party calling the witness, to be followed by questions from the opposing party. If desired, the panel will be allowed to ask questions. The panel may, but will not be required to allow further questions based upon an opposing party's questions or the panel's questions. The parties are encouraged to avoid calling witnesses that are only cumulative and add nothing to testimony that has already been offered. Evidence. The parties will be permitted to submit written documentation in support of their positions and arguments without the formality of the rules of evidence, copies of which we've already been provided. The presentation of documentation may be done during the presentation of your case, during summation, or at the close of the hearing without the need to read the evidence into the record. Evidence presented in this format should consist of a copy for each panel member and the panel member's attorney, the reporter, and opposing counsel, which everyone has complied with, and I appreciate all the effort that you've put in to accommodate the panel in that regard. The panel reserves the right to alter this process at any time during the process. Summation. Each side will be permitted to make a summation or a closing statement to the panel at the end of the evidentiary period. And once that is completed, the public hearing process will terminate, And the hearing panel has already decided to meet next Monday at 3:30 in this same location to deliberate, discuss, and hopefully make a decision on the petition that's before them. That will be a public meeting, but will not be a hearing. So it will be a situation where the panel will discuss the evidence that's presented and hopefully ultimately make a vote on how to respond to the petition. I believe we only have 2 witnesses today unless we're surprised with something, so we won't need to separate any witnesses. And at this time, the 2 witnesses that are going to testify, if you would please stand and raise your right hand, we'll have the court reporter swear you in together at the same time.
Do you swear or affirm that the testimony you give today is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you. Thank you very much. I'll turn the hearing now over to the chairman, Bill Horan.
Okay. Well, first off, I just want to thank everybody for coming, and we do appreciate, I'll echo Tony's words, we do appreciate the cooperation and working together and making this a very professional and civil process. So basically, we're going to start off with the presentation of witnesses, and I believe, Mark, I think you're first.
Yes, I believe there'll be opening statements first.
Oh,
Yes.
I'm sorry, yes, start with
we'll-
opening statements.
and
Sorry.
I'll start with, thank you very much, Mr. Chairman. This is going to be a very unusual matter because there's not a lot of factual disputes. There are some factual disputes, but we're going to have from the Yergi State Road Barbecue LLC, and I think after talking with the council for the county, we agree that although we raised some issues in our petition about who this was for, it's with the restaurant and the LLC and Yergi's State Road Barbecue, and that's who we're here for and who I'm representing and who Matt will be testifying about. The testimony will be quite simple, but really what this is about is, did the governor, and you all get the opportunity to look at, did the governor's executive orders exceed his bounds? Because your job is not only to determine the facts, but determine, as the panel for the Board of Health, whether the Wells County Health Department and its representatives had the power and authority to even do what they do, which they said in their order was based on Indiana Code 1619-311, which will be some argument about what that is in summation, about what that means. But there'll be evidence that is in your packets that were presented to you concerning those issues and whether that's effective or not, and then the governor's executive orders and whether the governor can do that or not. And in summation, I'll be arguing about it, but the evidence that's presented is going to show that the face masks, the restrictions on capacity, the restrictions on distancing are all over the place, is what the evidence that will be presented to you is going to, that we'll present to you with this, can be considered arbitrary, capricious, and unreasonable. And why is that important? Because it's the legislatures, and legislatures, for example, are like the General Assembly of Indiana, the county commissioners, except for budget things, then the county council does that stuff, town councils, city councils. They make the rules, not one person just saying what it's going to be, and it affects the whole state for a period greater than 30 days. So the evidence that is in your will show these things. And what's going to be presented to you, the type of evidence, will be a map taken from the Restaurant Law Center showing current, at least as of a few days ago, state indoor dining occupancy requirements in each state. It's a map that's part of the Restaurant Law Center return to work state guidelines for food service establishments that will be presented to you, that has all the states, and will have everything that I think the evidence will show that they're varied all over the place on what they do. You'll have current U.S. COVID-19 travel restrictions state by state, and the purpose of this will be to show that they're all over the place too. And you're going to have the list of coronavirus-related restrictions in every state. I believe this is from the AARP. And you're going to have also a map from the CDC that shows where COVID is as of just a couple of days ago and where it's worse and where it's not. And the map is included in black and white in the next document, which is from the CDC, which is the COVID data tracker. And the evidence that's being presented for you is to show that if everything is all over the place, you can make correlations, you cannot make correlations. The problem is that it's all over the place. And I will argue that some states are doing something different than other states, and it doesn't match with what all the other states are doing, which shows, and we'll be arguing about whether it's capricious and arbitrary, what's out here of having a governor just dictate what is being done and what is being said. So the guide to the arguments that we have that will be here is in our petition. For a petition to the Board of Health, it's about as thorough as you get to show your arguments, our resources, and why. And I'll argue a little bit more about that at the end. Now, there will be some testimony by Mr. Matt Yergler. Matt is the chief employee, chief manager, runs the whole business. There's no dispute that his wife is the sole owner of the LLC, but she won't be testifying. He'll be testifying because he's on the ground. He can testify about what was happening, what was not happening. And he's going to testify, and there's going to be no two ways about it. One of the citations is that employees weren't always using their masks. I don't know how many they're going to say or if they're going to say, but we admit that there were employees that weren't, because the policy there was the employee's choice whether to wear masks. And Matt's going to say he didn't all the time. So that is something that we can't get away from, because we agree that's a fact. And that's part of the violation for this order. Where there is disagreement is whether the tables and booths were 6 feet away or separated by physical barriers, and was the capacity 75% or less. Matt's going to testify about those, and that they were meeting those two things during that. But with the admission, you've got an order that if you find that the order is valid, then we understand what you're going to rule, but we're going to be asking at the end of this case for you to find that the proper due process for Indiana, the proper way to treat regulatory actions which are not created by agencies, they're created by legislative bodies, that the proper process for dealing with this if something isn't right is to have those agencies do it, and even do it quickly. That no one seems to have done that. And we're going to ask you that the Board of Health of Wells County and its enforcement officers went farther than their authority to issue this order. They did not have the authority, and we ask you to find the facts on the other two issues about what you believe is the case on the 75% capacity and the 6-foot distancing issues that were also cited in here. That's a quick summation of what it is. I think that covers it. A lot of material here. I may not be asking you to read it all, but it's there for you, there to peruse and to see the arguments that I'm making, and will point out at the summation at the end of the presentations here, at the end of the witnesses. And I will be asking you, after we've had the witness presentations, when we have the formal presentation of exhibits, I'll hand it up, say what it is, tell you what it is, a little bit about it, and then we'll move on to the next one. And of course, the attorney for the county will do or for the Board of Health will do the same. Quick summation, that's what it's all about. Fairly simple, but it's a very, very important issue.
Thank you. The Health Department's position is that it was following executive orders issued by the governor, one of which requires the wearing of face coverings by a restaurant. That has not been done. The Health Department followed the directions of the governor with respect to enforcement. There's steps indicated in Executive Order 2026, We submit the department followed those guidelines, issued verbal orders, written warning, and then an order of closure when compliance was not made. Everybody but the key manager or one or two employees doesn't do it. I mean, it says you will wear face coverings. And the fact that different states and different rules and this and that, we submit the governor's order was proper according to the authority granted to him under the emergency management law. With respect to, are there some states that do something different, or do you disagree with, again, under contentions, face coverings that are not effective, this and that? Our submission, I'm tired of printing out reports. I mean, here's face coverings, and here's the studies behind the reports regarding face coverings. Face coverings are effective. And even if there's some disagreement about it, the issue is whether or not the governor's order was an appropriate exercise of the police powers. And the cases that we cite, U.S. Supreme Court, and I think there's 4, Indiana Supreme Court, is you to prove it beyond a reasonable doubt. People can disagree. The issue is whether or not the order entered by the governor is a reasonable exercise and not arbitrary and capricious. So we submit the governor's order was lawfully issued. There was no compliance, and the order to suspend operations is lawful. Thank you.
Okay. So at this time, we have the presentation of witnesses.
Yes. Can you please state your name and make sure you speak to the mic because the court reporter is recording this?
Matt Yergler,
And for whom do you work?
Yergis State Road Barbecue.
And it's the entity we're talking about in the opening statements here and concerning the order of abatement, correct?
Correct.
What do you do for Yergis?
Well, I do just about everything from managing it to preparing the food to managing the employees to managing the operations. I do almost everything besides the paperwork side of it.
And were you doing such things and working for Yergis on August 28th, 2020?
Yes.
And that's the day where the order of abatement is cited towards. Yes.
That's my mic in the corner.
Oh, I'm very sorry.
Th-
Sorry. So you were doing all that work on August 28th, 2020.
Yes.
And do you recollect having any enforcement officers stop by that day?
Yeah, Brandy stopped by on that day.
And on that day, could you tell me what the restaurant's policy was concerning masks and employees wearing masks?
Yep. The policy was that if you wanted to wear a mask, you could. And if you rejected or had reasons not to wear a mask, then you were not forced to do so.
And did you in fact have employees not wear a mask that day?
Yes.
On that day, do you know how the tables and booths were set up in the restaurant?
Yes, we had the table set up with social distancing in mind. We were following the guidelines that Brandy gave us on how to set up our dining room. So we took tables out when we were supposed to, and then we were under the 75% capacity.
And that was based on the guidelines that you had received previously from Brandy of the
Yes.
Health Department?
Mhm.
She's here in this room today, correct?
Correct.
Yes, okay. So on August 28, 2020, were your tables at least 6 feet apart or booths, if you have any? Or
Yes,
were there
correct.
did you need to have any physical barriers between tables?
No, we did not
comply?
need to have any to comply.
All right. And was your capacity under 75% or under that day?
Yes.
Was that
it was.
because you had removed the tables?
Not that day. We were always operating like that.
Okay, you were always,
Well, so when it started off, I think it was 50. So we were at 50. We never increased after 50.
so you were actually
So
at
we were
50%.
we were way under 75%.
Okay.
We never brought any tables in once we were able to. We just kept it at 50%.
All right, I have no further questions.
I have no questions.
All right, we have no further witnesses. Oh, could who, just,
Does the panel have any questions for the witness? No? Okay. So, panel has no questions for the witness. So, Roy, present your witness.
I call Brandy Shore to testify. Would you please state your name
Brandy Shorey,
and your occupation?
Environmental Health Specialist.
And you heard Mr. Yergler's testimony, did you not?
Yes,
And the order to abate cited noncompliance with capacity and spacing, is that correct?
it did.
And that's based on your inspection of the premises?
On that day, he's correct. There was appropriate spacing, and they were under 75% on August 28th. That is correct.
Were there problems in spacing and capacity on previous days?
With lines on weekend nights, with lines and people waiting for carryouts and things like that is what was reported.
Okay. The requirement with respect to face coverings is customers don't need to wear face coverings while they're seated at the table, but standing and not seated, they do. Is that correct?
Correct.
Okay. I don't have any other questions.
I have no questions.
Does the panel have any questions? Panel has no questions? So is it time for summation or do we?
Yeah, why don't we have you go through your exhibits
Mhm.
individually, whatever you want to cover, that you don't, I mean, you don't have to
Sure.
go through them all, but no need to duplicate what you've already produced, but if you feel the need to explain something here
Yes.
while you've got the panel in person.
I would prefer to do
Yeah.
that, to help them understand why they're
Sure,
there, and then
sure.
we'll do summation on it.
Sure.
First is petitioner's exhibit number 1. We have our arguments about the law in here. As importantly, we have the exhibits of all of the executive orders for you are in the back of it. And we also have a copy of the order to abate. The issues are addressed on page 4 is issue 1 concerning the general statute from the Indiana Code. And I will be arguing in summation that I consider it broad, but I wanted to let you know that that's there, and that's where we'll be referring to in our summation. Issue number 2 is on page 5 of that exhibit, and that concerns the governor's executive orders and any authority to do so. And then our third issue talks about the emergency management disaster law itself. And I will be doing summation in a little bit here concerning those issues. You will have in your petition, if you've had a chance to make your notes on anything, this right here is a colored copy of labeled Petitioner's Exhibit 2 of the map that's in Petitioner's Exhibit 3. So you can see what it is, and it's much clearer, and see how it works. And it's about restaurant capacity by the states. And although I don't have any articles on it, New Jersey's now different. It has changed it late last night. So
When you say capacity, you mean
How many
pursuant to
people-
whatever the order the governor may have ordered in that state, that's the maximum capacity?
that's the maximum capacity of the restaurant. And you'll see here it's still, as was at the time on August 28th, 75% for Indiana. Other states you can see here by the color code what their capacities are. and what are allowed. And one thing I do want to make clear about this, because the attorney for the county did mention it, every state has different things. We're talking about what is appropriate for Indiana. The purpose of this is to show the variation of what's out there.
Do you know
Mhm.
the date of this, of when this was?
Yes, this is a copy from here. It's dated on here, Petitioners 3. It's from the Restaurant Law Center of the National Restaurant Association. It was updated on November 5th of this year. And that's the cover sheet. This is all from their website. And Exhibit 3, which Exhibit 2 is a part of, I don't think I made a copy of that, but it's the map that was with it to show the capacity. It has every state's summation of their capacity of rules. Now, there are some things that are for links, but the purpose of this is showing each state has a lot about what their restrictions are. And I'll be arguing later that this shows that there's not agreement on what they should be. Petitioner's Exhibit 4, and I'll let you look at 3 for a little while longer if you need to. But every state I've just included in there. This is from a CNN website, and I just have that in here to show the travel restrictions by the states. And the purpose of it is to show that all types of things are being done all over the place on what's being done. And trying to do cause and effect on what's working and what's not is a really big thing. And I'll be arguing later who's the appropriate people to do that in Indiana. That's Petitioners 4. Petitioners 5 is from the AARP, and they have a list of coronavirus-related restrictions in every state. It serves the same purpose as Petitioners 4, which is show you the variations that are out there, what's out there, and I'll be arguing the difficulty of correlating what's working and what's not. Petitioners, and that's all, both the travel restrictions and the COVID restrictions generally are for all 50 states. This right here is a map that's from the CDC COVID data tracker. And it shows you, and you'll be able to see from the exhibit, Petitions Exhibit 7, what this all means on it, because it didn't go state by state to show what this means, but it's color-coded to show where COVID has the most cases and where it doesn't for population. Again, the black and white is in Exhibit 7, but it was hard to see, so we made a color copy of it. And these are all from internet website. And it has a list, and this is as of November 9th, which is yesterday. Updated last on yesterday. Again, we'll be arguing and showing that this shows that it's hard to figure cause and effect and correlation in all these policies right now. And then Petitioner's Exhibit 8 is just a word search how COVID restrictions are effective in the first 2 pages from a Google search, and I'll talk about it in my summation. And that right there is a documentary evidence that we have presented for you to consider when you make your decision on what to do about this situation. Thank you.
Yeah. So I guess instead of waiting until your summation, which should be a summation, I think the panel would be better, since you've explained your exhibits, to make your argument now with your exhibits.
I am fine with that change.
Is that okay?
I am more than fine with that. I think that's a good way to do that.
Yeah.
Thank you. So you have all these exhibits here in front of you. And the first thing I want to do is talk about petition number 1, and I want you to go to page 5. And that's the violation of distribution of the powers clause. Indiana, if you read cases and other people who write about it and pine about it, Indiana's Constitution vigorously and rigorously separates the branches of government. I would argue more so than the federal Constitution does, and it has a pretty good division as well. The executive does what it does by enforcing the laws, running the day-to-day activities of the state. The General Assembly, our legislature, creates the laws. They make the decision. They use due process with committee hearings, with votes, with more than one person making a decision on what the law should be, what the restrictions should be. They make the decisions, not government agencies. Government agencies enforce. The governor enforces. The question is, with the emergency law that says he has 30 days emergency power, can he do that? Well, I'm not going to argue that because that 30 days has gone way too long. Because that 30 days ended a long time ago. These executive orders started in March. And now it keeps going and going and going. And I'm going to go into a little arguing. Is that the contemplation here? Just
Yes.
do it now. Is 1984, a wonderful book about a society that was really messed up. And I'm not going to say read the whole book and you get this one. That's all I'm saying. What I'm going to say, though, is what I'm seeing with the governor, with this keeping with the emergency order, and not calling the legislature to deal with the specifics, is much like the war in 1984, where it was a perpetual war. It was always a war. It was always an emergency. It never ended. An emergency ends. It becomes routine or rote. It becomes something that we deal with. It's no longer an emergency. We're just dealing with the after effects. It's a tornado going through your town. And having people be able to make quick decisions on what roads we block, how do we do this, how do we get to where we need to go. But after 30 days, we now know what we're dealing with. And the legislature, even if it could properly, under the Indiana Constitution, give the governor the authority to do that, it's now the legislature, the General Assembly's role to make those decisions. I'm going to be a little silly here, but in our system of government, nothing's perfect. You can't be too capricious, you can't be too unreasonable. If you have due process, you probably aren't capricious or you aren't being unreasonable, and that's what a General Assembly does. And if you disagree with them or not, they've gone through a process where they've hopefully gone past the capricious element, past the unreasonable. You may not like the decision, but they have worked hard to figure out what it is. The public can say things. The public's invited to look at this, of course. The public can make comment at committee hearings. 150 people make a decision on what should be done. And the process, if done correctly, is a good process. If there was a need for 30 days to figure out what to do as it's happening, which there was stuff happening before that might have suggested maybe the General Assembly get called really quickly anyway, because this was heading this way. But if it started the date that he declared the emergency, he could call the General Assembly in together and say, here's what I want. This is what we need, and here's why. And then they have their process. If they need to do it expedited, they do it. They stay up all night. They have lots of hearings. They make a decision. If the General Assembly had made this decision, and if it wasn't too terribly capricious, too terribly arbitrary, we may not be here today. But there's no authority for the governor to do what to do. The governor's executive orders are to run government. It's to tell government what to do, not Yergler's barbecue. That's the General Assembly's role. So right here, right now, we're in here, you notice that Matt doesn't like to wear masks. He's got a condition that causes him discomfort over long periods of time. He's got some philosophical reasons probably on that. But he's wearing a mask because who is it that controls this building? It's the county commissioners. Now, I don't know, and I haven't researched because I didn't think it was that important, but I would say that if they wanted to make rules about the use of the building, they have that authority. But they don't have the authority to tell them what to do unless they go through the due process of hearings, of having public hearings, voting on it, debating it, etc. It is Yergler's place of business. They make the decisions for that. People who go there make the decisions of whether or not they are safe or not. Unless the General Assembly, through its laws and through getting more specific, and through agencies, when they realize there's a gap that things should be addressed, asking the General Assembly to fix it, then the rules become obvious, and the rules then start applying to Yerglers. But it's not the governor that makes that decision. It's not one man keeping an emergency going on and on and on. The Board of Health here in Wells County is in a situation, does the governor have the authority or not? They chose that they did. They do not. They could not do that. I have seen nothing presented in that order, nor do I know of anything where the county commissioners tried to do anything like that. Whether they could or not is a totally different debate that is interesting, but what matters is the Wells County Board of Health used the state governor's executive orders to do this. He's not a legislator. They're legislative proactments. So the order fails for not having a legal, lawful basis to be here, to have it. Now, I'm going to back up a little bit. What if you do find that the governor can make those decisions, even if you think their policies at the General Assembly called in earlier? I say that he couldn't do that, but let's say he did that. Well, the General Assembly, they're human, just like everybody else. The General Assembly sometimes does unconstitutional things. We've all seen that happen, or a court declares, well, no, you goofed up. Quite frankly, it's amazing how little it happens, but it does happen enough that everybody knows it happens. And this is where the Indiana Constitution comes into it, because Article 3, Section 1 of the Indiana Constitution clearly divides the powers and makes it very clear that one branch doesn't do the work of the other. If you look at the law, and this is personal to at least 3 people in this room, who makes the rules about attorney discipline? If you read the Indiana Constitution, it says the judiciary manages who practices in courtrooms. That's my summation of what they say. They use some 1850s language in there, but that's what it is. The governor doesn't do that. The General Assembly doesn't do it. The judiciary does it. Same thing with the governor enacting legislation concerning how to handle things like social distancing, distance of tables, restaurant capacity, whether you wear masks or not, from a statewide level. You can't do it. It's a violation of the Indiana Constitution. So in page 4, issue 1, the violation of the Indiana Code. One thing that's very clear about emergency orders and enactments and enforcement of agencies, be it a Board of Zoning Appeals, a health board, etc., is that they have legal authority to do it. And they don't create the laws. If there's a gap, they're to go and say, hey, county commissioners, we see a problem here, we can't enforce it, we think it's a safety issue, make a decision on whether it is or not. So we have due process. Otherwise, no one knows what the law is. Let's take speeding, for example. speeding, we have speed limits. This is how it works in Indiana. A lot of people don't know that. A lot of lawyers who do, especially lawyers who've defended people for speeding tickets. The General Assembly sets the general parameters. And then under the concept of home rule, it allows some movement around within those parameters if done by ordinance of a county commissioners, a city council, or a town council. And if you go to a speeding, you have a speeding ticket, the first thing, if it's contested, is what's the authority for the ticket? Is it the town ordinance, the county ordinance, the city ordinance, county ordinance, or the state? And if the state allows a higher, if the state allows something differently and the town or city does not have the authority to deal with it and change it, or change it lower than what the parameters are, and you see it in a lot of the larger cities like Fort Wayne and Indianapolis and Gary and stuff like that, where you see these artificially low speed limits, they may not be effective because the General Assembly says in an urban area, this will be the minimum speed. And if an ordinance hasn't been passed, you default to the state. Doesn't matter what the sign says, doesn't matter what the people enforcing it or what the police think they want. I'm not going after the police or anything, but what the police want, or that they're the enforcement agency in a speeding situation. What matters is what the General Assembly said, and it's the same thing here. Is it clear? Do we know the boundaries? Is it properly promulgated? That's the big lawyer word for it's been acted upon and announced by an authority that can do that. And then with violation issue 3 in the petition, I've talked about that, about the emergency management disaster law. The executive orders are arbitrary. Now, does arbitrary mean it's a bad idea? I don't know. We may know someday whether it turned out to be a bad day or not. What arbitrary means is, why is it? Why was it pulled out? It could be for many reasons. But of the other exhibits coming up, you're going to see that everybody's all over the place. And the other petitioners' exhibits, you see that when you start correlating things, there's no consistency out there about why is one state allowing more capacity than another state, even though it has less of a COVID risk, or more of a COVID risk. I mean, you've got that all over the place. The travel restrictions. Are the travel restrictions causing things and not the restaurant restrictions? Are they working? Are other restrictions working? It's hard to tell. And our process in Indiana is for our legislative bodies to decide that and not be unreasonable. And when an agency, I'm not attacking the agency, I see this quite a bit, they're eager to do what they think they need to do generally, but they need to do it specifically what they're told to do, and they can't create what it is. It violates property rights, it violates rights to assemble. Those are all major constitutional issues that are out there, that if they have to do the right process before they start doing that. They cannot decide what it is. Now, I'm not saying that Wells County did it because they glommed onto what the governor did. But the governor is just like the Wells County Board of Health. He has to do it proper too. And after 30 days, I'm calling the General Assembly, any sort of semblance of him being able to do that disappear. Because when does emergency end? Or really, in Indiana, our emergencies, like the war in 1984, they just keep going on and on and on. As long as the one person says, they keep going on and on and on. Petitioners Exhibit 3 and 2, which is the occupancy maps. You'll see what everybody has. Some are different. Can you argue maybe there's some correlation to some of the states being worse with having higher occupancy? Well, yeah, you can also argue that there is no correlation from here as you go through this. You can see some that are having problems even though they have a low capacity. It's all over the board. Again, one person without due process picking these things is improper. And I don't care what his basis and background is. It hasn't been done under the rule of law. The rule of law is what's important. So that Yerglers know, the Yerglers here, and the Yergis State Road Barbecue knows what the law is and that it's been properly enacted. And it's just not drawn out of the hat. Why are we at 75% and Ohio's at 100%? Why is Oregon at 100% but it has a real high COVID rate right now? And we're at 75% with the lower one, although higher than a lot of others. That right there tells you the arbitrariness and capriciousness of the governor's figures, even if based on something else. And if he wants to get that around, and if he wants to get that so that it isn't, he's got a simple solution called the General Assembly to session. It's not that hard. And if it truly is a bad thing, the cost of putting them together is the price we pay for rule of law. Big deal. We can afford that. We'll figure out how to do that. Again, if the General Assembly had been here and went through all this and we had all the processes and it made it clear, the question would then be, do they have the authority to do that? It's a totally different question, and we probably wouldn't be here. Exhibit 3, again, is all of the restrictions. They're all over the place. Some are consistent, some match higher COVID rates, some match lower COVID rates. There's some consistencies among some states, but then you find a state where you don't have it. And I have that there for you so that you can see it, because the National Restaurant Association has put it all together for their members so they know what it is and what's going happening. And they let the public look at it too. They want the public to know as well, because it helps, presumably helps their clients get more business knowing what's going on. And then I've got the travel restrictions state by state and the coronavirus state by state again. If you go through this and look at this, you'll see all types of issues that are out there, all types of restrictions. And then compare it to where we're the worst, which is the dark blue areas, South Dakota, North Dakota, Wyoming. Wow, that's a change. Indiana's the next tier, other tiers. Are there some correlations you can argue? Probably. Are there some correlations that you can't argue? Yes. It's all over the place. Again, this shows that the decisions of the governor are based on something other that is some type of capriciousness and unreasonableness. I keep harping on this, but I'm going to, because this is the nut of everything here. The Indiana Constitution says, no, executive, you're right here. Judiciary, you're right here. Executive also has administrative. Indiana's an interesting constitution because it lumps both of them together. And the judicial. And they only meet when they're allowed to meet. And that is when the General Assembly gives the bills to the governor and says, no, we passed it, now enforce it. There are no bills, nothing out there by the General Assembly that directly and not broadly, you can argue anything. Lawyers, we're really good at that. We can take stuff and say it's really broad. We can say it's really specific. But if you look at it, it's broad, but they're arguing that it allows specific things. No, the General Assembly does that. I know that's a lot of law here. This isn't a dispute where, yeah, we did it, no, they didn't, which is the more typical Board of Health hearing dispute. And my client has admitted no mask on that date and disputes the other things, but we've got to, if you decide that the Board of Health has the authority from the governor, then that's what it is. We'll go from there how we can, well, we choose to do. But they didn't have the authority. And the most frustrating thing in summation, and the final thing I want to say is, it has been so easy to clear it up and not have this happen. And everybody knows what's going on, and it was clear and what to do. Well, I won't get into the politics on it, because it doesn't really matter for here. But that's not an excuse. What matters is the rule of law, is the due process, the law followed, The emergency is way over. We're pretty used to it. We're getting used to how to handle this, and we made our own decisions on how best to protect ourselves. It's about Yergis State Road Barbecue and its property rights, the rights of people to go where they want and decide their own protection, where they want to assemble under the Indiana and U.S. constitutions. And the Board of Health, took a governor's mandate without authority and issued an order of abatement and closed the restaurant down. That this should be stayed and allowed to go into business and be open, and until there are properly enacted ordinances or laws that meet scrutiny, then he should be able, or not he, but the restaurant should be able to do what it wants to do and what its customers want to do. Thank you very much.
The rules of procedure for the, set by the panel, allow verbal, oral presentation as well as written. So I've got 32 pages of submission containing my arguments. I'm not going to repeat them for you, other than to say that in reviewing the petitioner's petition for review, they're saying there's absolutely no basis for a face mask requirement on employees that are healthy. So fine, I've got 25 studies about face mask requirements. The problem is that COVID transmission is also by people who are asymptomatic, who aren't ill, who don't show signs of illness. And that's the reason for the face mask covering for employees. One of the exhibits is Dr. Fauci. 2 places you shouldn't go, restaurants and bars. Okay, fine. Why? Because people congregate. The face mask requirement, the advertisements or the Facebook posting by Yergis is, we're fighting for your freedom. There's never an order requiring the customers to wear other than if they're standing. If you're seated, you don't have to. You're exempt from it. The issue from the health department standpoint is employees who are handling food. They could be asymptomatic. You wear face masks not for you to prevent from getting sick, but from you to prevent spreading other people. It's transmitted through vapor, through air, and that's why it's effective. So our exhibits show, there's numerous studies showing the efficacy of face mask requirements. Now, when you get into the authority of the government, or the governor, Exhibit 16, I set out in its entirety the emergency management and disaster law. Mark is correct, it said 30 days, but it's also renewable. I don't think it's relevant, but recent decision by the Michigan Supreme Court went against their governor. But their law was she had authority till I think it was April 30, and the legislature did not extend that. We got 50 states in the District of Columbia, different laws, different procedures. Indiana's allowed the governor to renew that emergency. When the orders were first issued, you had the curve, bend the curve. Now you look at the curve, and I think Indiana's reporting on a daily basis, I think over 4,000 COVID cases. I think Illinois might have been 17,000. I know what Ohio was 7,000. It's not getting better, it's getting worse. So in terms of the pandemic going away, it's not happening. There's a need for that. And I think that the face mask requirement is reasonable. There's certain scientific evidence to back that up with respect to the constitutionality. There's other people who disagree. I've cited and included in the materials reports from 3 professors with respect to the constitutionality of the face mask requirement. Again, it's an area where people can disagree. The Attorney General has a different opinion. That's fine. People are, opinions are like other body parts. Everybody's got one, So people can disagree. The problem is with respect to a reasonable exercise of police power, does not the governor's order have a rational basis for protection of the people? And if so, then it's enforceable. It doesn't have to be perfect. You might disagree with it, but as long as there's a rational connection to promoting the good, I think it's enforceable. With respect to separation of powers, again, I have cited and included, I think, 4 Indiana Supreme Court cases on those issues. And with respect to one, Mark should know, I think he was counsel in that. So it's been litigated. And I think the case that Mark was in had to do with whether the Board of Pharmacy had authority to create laws with respect to spice or fake synthetic drugs. The Supreme Court upheld the delegation of that authority to the Pharmacy Board. Now again, Mark would be the expert on that. There were careful controls over that authority, but to say that the legislature's got to do all these things, it's not the case. And so, like I said, I cited three or four Indiana Supreme Court cases, plus the U.S. Supreme Court case that's the leading case as far as citing the Jacobson case. These cases involved delegation of authority to different local council or school board. One of the cases even is out of Wells County that upheld, I think it was the local town council, or the local health board, to make an order with respect to school immunization. It's interesting that these cases involve smallpox, so, again, another health issue or crisis before us. I'm old enough to know that there was a time when the legislature met every other year, not every year. Now we think we've got short and long sessions. But there needs to be, and the legislature has given, under the Emergency Management and Disaster Law, authority to the governor to do just what he's doing. We submit that the law is constitutional and the order was lawful and it should be upheld. In terms of personal freedom, there's a balancing test between the rights of one individual and the community. And we believe, and I cited in my argument, that there are times when the community prevails over the right of that individual. The tyranny of that individual to prevent protection for the community. Thank you.
Do you gentlemen feel the need to summarize your arguments anymore?
No, I think we did
You did a great job.
Yes.
Appreciate that. Anything else from you for this matter?
Panel have any questions?
Mhm.
No? Okay, so why don't we close the public hearing portion? And I got some discussion I want to have. It's still a public meeting, so we won't be taking any more evidence or whatever. I want some direction from you three, because you've heard a lot of very little factual disputes, a lot of legal arguments and things, so I need direction from you on what you might want from me from a legal perspective, if you have questions on the law and stuff. And I guess I would encourage you, as you review these materials, to individually reach out to me if you have specific questions on the law and things like that. We can't do it as a group unless we're in a public meeting, okay? So individually, if you have something, a question for me, either give me a call, send me an email, whatever you want to do, and we can talk about that one-on-one, and I won't discuss it with the other panel members, only if they call me and ask me the same question. But then, if you have, after you've thought about it, if you have something from a legal perspective that you need me to respond to the panel, then I can be prepared to present that next Monday at 3:30 on the 16th, right? when we're going to meet again for you to discuss this and make your decision. It's just, it's, you know, it's a public entity that's requires to have public meetings. You can't have discussions as a group outside of a public meeting. So since there's only 3 of you, 2 of you can't get together and talk about this outside of a public meeting, okay? I want to make sure you understand that. But you can contact me individually with any specific questions you might have. Either of you have any comments on that?
We were hoping you would just condense these down into a 2-page summary of each stop. And
Well, I could go through the electronic copies they gave me and delete a bunch of stuff. No, but I'm a little perplexed as to how to present any kind of a written decision that, might be made unless when they do meet and decide on Monday, if they want to express their rationale for their decision at that point in time, whatever it may be, I can put it into writing, or it can be short and sweet. I don't know what they're going to decide, so it's a difficult job for me to try to figure out how I'm going to approach that, but
Understand.
yeah. So we'll do the best we can to get you a decision next Monday in public, so that whatever either side needs to do going forward after that, they can make a decision to do. I apologize for the length of time it's taken to get this to a public hearing, but it's not really anything I had any control over, so.
we have a finding, you gave us a findings of fact.
Right, the findings of fact and proposed.
And- And are we going to have a finding of fact, is that?
I intend to, but I think the deadline's later.
Yeah, well, you have until Thursday, I think it was, to present that. If you had supplemental, anything supplemental after today, plus proposed findings, yeah.
So just clarifying that was,
Right.
okay, got it.
And I can take those and give the panel alternatives.
Mhm.
So, as we both know, sometimes the judges just like to take what was given them and just sign them.
Sometimes I get in trouble with it.
Yeah, I know.
They do.
So, anyway, any other questions?
Well, so I guess we will conclude this hearing. Thank you all for attending, and I really appreciate your cooperation in how the hearing went about. So
Thank you.
we will meet again on Monday, November 16th at 3:30 PM.
Thank you very much.
Thank you.